Hi everyone. We're hope you had a really good short coffee break. We're now going to start into panel two, and through the magic of technology, we've got Professor Eleni Franci online. So I'm not really going to do an introduction. Eleni, thank you so much for coming virtually. It's great to see you here, and we're going to hear from you on unpacking the law and policy challenges of Article 2 and the Charter of Fundamental Rights as well. I don't need to do anything online, do I? Do I need to? No? Great. All right, Eleni, take it away.
Thanks very much. So I won't say it very much by way of introduction either. I will just get on with the slides because I do have quite a lot of ground to cover, and I'm persuaded that I should stick to 15 to, well, under 20 minutes to allow for time for questions. There's quite a bit to cover today. So my presentation will be about the application of the Charter of Fundamental Rights under Article 2. This is based on a piece of research that I co-authored for the NIHRC on the application of the Charter and General Principles of EU law in 2024, and also a subsequent article in the NILQ with my co-authors, Professor Tobias Locke and Anurag Deb. I will try to do them justice. I will try to cover all aspects of the report, although this has been a collaborative project. What I will add that is a bit new is that some things have changed since the Dillon judgment at the Court of Appeal. So I will try to add those in, and I'm sure that Chris will add some more thoughts on the Dillon judgment later as well. What I will do is keep my presentation to about 4 points. So just give a very brief overview of the status of the Charter in the UK post-Brexit and how it works within the Windsor Framework. And then talk about the challenges of applying the Charter under Article 2 of the Windsor Framework, why we should care about the continued application of the Charter. So what does it actually change? What does it do? Or what could it do? And finally, I'll try to conclude by asking the question of whether the Charter actually applies. And spoiler, I mean, the answer to that question will be yes. But I think to an extent it now seems to depend on who you ask. So I'll try to say a little bit more on this on future directions. So I won't spend very much time on the basics. As I think you perhaps all know, the Charter of Fundamental Rights was one of the very, very few things that the Withdrawal Act 2018 removed immediately from domestic law after Brexit, even though there had been initial commitments to maintaining the status of fundamental rights in the UK as a whole. Nevertheless, the Charter went. The EU Withdrawal Act had initially retained the general principles of EU law, but those are gone too following the retained EU Law Act, which entered into force earlier this year. However, that state of affairs is, of course, not necessarily applicable in Northern Ireland as a result of the withdrawal agreement. Section 7A with Section 7A of the EU Withdrawal Act, as amended following the withdrawal agreement, providing effectively the same sort of conduit pipe for EU law as we had under the ECA 1972. So all such rights, powers, liabilities, obligations, and restrictions from time to time created or arising by or under the withdrawal agreement, etc., basically shall remain applicable in the United Kingdom. And that's to say that the Charter can have continued relevance not only in respect of the Windsor Framework, of course, but also in respect of the entirety of the withdrawal agreement. And this is, in some respects, a little clearer because the several provisions of the withdrawal agreement will have to be interpreted in the light of the Charter. But you have asked me to talk about Article 2 of the Windsor Framework in particular. And this provision, as we've heard already in the first panel, is about is a clearer non-diminution protection. So, of course, it comprises the Charter of Fundamental Rights conceptually. The Charter was part of the rights apparatus of European Union law before Brexit. Any, I think, assertion that diminution of rights may not comprise rights that were contained in the Charter, I think would simply be unreasonable. And we know from a range of cases that there is no such insinuation at all. The rights that were protected in the Charter are not within the scope of Article 2. The question is, how are they brought in? As we know, The non-diminution commitment in Article 2 is a twofold commitment. So there's the Annex 1 dimension, which is prospective in character. We know what the provisions are. They're the six equality directives as amended, as they continue to be amended by the European Union over time. And the relevance of the Charter to those directives is very clear. Not least because most of them, especially the new ones, make quite extensive references to the Charter in their preambles, and especially to the non-discrimination provision, Article 21 of the Charter. But that's not to say that only Article 21 is relevant. Those directives are to be interpreted in accordance with the Charter under European Union law. And so even when domestic courts are interpreting provisions pursuant to those directives, of course, they need to take account of the Charter. That's I think, fairly uncontroversial. What is a little bit more fluid and unclear, of course, is the RSEO section, the rights, safeguards, and equality of opportunity, part of the Good Friday Agreement, where the relevance of the Charter may not be so straightforward. And that provision, as Colin mentioned earlier, is frozen in time. So, of course, we can't necessarily look to the case law of the European Court of Justice prospectively. We're looking at it only up until the end of the implementation period. Now, how can the Charter be relevant in the RSEO section? Well, of course, the obvious thing would be to say there are Charter provisions that broadly correspond to the rights covered by RSEO. For example, Article 1, dignity, Article 10, the freedom of religion, Article 11, the freedom of expression, Article 20, equality before the law, Article 21, non-discrimination, 22, cultural, linguistic, and religious diversity, 23, equality between men and women, 26, protection of persons with disabilities, 40, the right to vote in municipal elections, and 45, of course, the right to free movement. Now, all of these provisions, I think, almost directly replicate aspects of the RSEO section, but that's not to say that they're the only ones that could be relevant. As we heard earlier, again, provisions on fundamental rights are indivisible. You don't just have to rely on those that are clear or directly comparable to the RSEO section. Any aspect of the Charter is potentially relevant in supporting RSEO, and we have seen, especially Article 47 of the Charter, the right to an effective remedy, being quite clearly relevant in the IMA case, and also being raised in the Legacy Act judgment too. So that's to say, there are some very obvious links with the Charter. There are also some less obvious links. Any Charter provision can support the continued application of those rights, safeguards, and equality of opportunity protections of the Good Friday Agreement, provided that we are within the scope of EU law. And this is the real challenge, that these provisions of the Charter, or their existence, or the fact that they are similar to the RSEO section, do not in themselves create a right to rely on the Charter as a result of non-diminution. That's very, very important, and it has been raised in the Ishmael case, as well as more recently in the Dillon judgment. Now, as a matter of European Union law, that was always the case. So Article 51, paragraph 1 of the Charter provides that the provisions of this Charter are addressed to the institutions, bodies, offices, and agencies of the Union with due regard for the principle of subsidiarity, and to the member states only when they're implementing union law. They shall therefore respect the rights, observe the principles, and promote the application thereof in accordance with their respective powers and respecting the limits of the powers of the Union as conferred on it in the treaties. That means that whereas the Charter has always applied to the EU and its actions, it also, as a matter of EU law, applies to the member states only when they're implementing EU law. Now, that criterion is not very strict, and I want to emphasize that. You do have to go through the hoop of showing that there is an implementing of EU law. So we have to have some legislation that actually brings the Charter into the case. That has to be, as Paul Craig has put it, a hook onto EU law. The Charter is not literally self-standing. That means you've got basically to have another a form of implementation, say through secondary legislation. For example, a directive, and that's been the case in most of the judgments that we've seen so far. But, and this was an argument that was raised by the Human Rights Commission in the Dillon case, it could potentially be broader. We've seen cases like Franson, for example, the classic case in Article 51, the scope of the Charter, where implementation of EU law was considered to be a provision that was not, in fact, mentioning EU law, that was actually predating EU measures. Yes, so there was an EU competence and there was an obligation by the member state to take measures in this area. But the particular measure, tax measure that had been taken here actually predated that obligation in EU law. That was sufficient to get the charter to bite. So, you do have to be within the material scope of European Union law in order for the charter to be engaged. For example, you could have a freezing of assets based on an EU sanctions regime. Obviously, then you can rely on, say, the right to property or the right to an effective remedy under the charter. You could have an execution of a European arrest warrant. This is an interesting one because those don't always have the framework decisions on European arrest warrant do not always have direct effect. So I'll say a little bit more about that in a minute. But of course, those things can bring the charter and to bite. They show that we are within the scope of European Union law, and once we are within the scope of European Union law, the charter applies. There is one exception, which is. And it's not really an exception. It's a principle of EU constitutional law. The only cases where the European Court of Justice has highlighted that the scope of the charter is not engaged is where the member state is gold plating EU measures. So they're going well beyond what the EU law is requiring them to do. For example, in detailing a greater level of social security than a particular directive asks them to. In that case, an individual cannot rely on the charter in order to have charter provisions read into the legislation, because the legislation is not really implementing EU law, it's just doing things beyond EU law. A good example is TSN, another example is Hernandez. Now, I say all of those things because, of course, they're very relevant to the SPAC test, which we have heard about already, and that we will hear more about later, I think, and particularly to part 3 of that test, which is that the Northern Ireland law has to be underpinned, that the RCO aspect, that the diminution basically has to have been underpinned by European Union law, and that has to also be the hook that brings the charter into play. So the charter will apply in situations where we have an implementation of EU law in broad terms, as explained in the Franson case. And Franson is not the only case. The CG case is also a good example. There's more recent examples like the Mirren case that we can rely on. I emphasize this point because it is the most important challenge that we're seeing on the application of the charter, and we've seen it most recently in Dillon, where arguably the Court of Appeal took a quite narrow view of what an implementing measure is for the charter, and stated that we do not consider that the test on the scope of EU law is met simply because an EU competence is or may be arguably engaged. Now, that is correct as a matter of principle, of course, but it is important to note that in EU constitutional law, it is not a test that is construed very restrictively. And you can see, for example, the CG case where we were within an EU competence generally, and of course, there was also secondary legislation on the free movement of persons, but the matter was, in fact, the UK was going beyond what the secondary legislation required in allowing the individual residency. Nevertheless, the failure to comply with the right to human dignity was considered to be incompatible with the Charter. So, we do have much broader expressions of Charter applicability than what is suggested, I think, in the Dillon judgment at the Court of Appeal. So I think it's important to say, well, the scope of the Charter is the challenge. We need to go through that hoop. It's impossible to have a case unless you show that there's an implementation of EU law that brings the Charter to bite. But that step is also not as strict as perhaps it appears to be in the most recent case that we've seen. Now, why does all of this matter? Well, for various reasons, of course. The Charter informs the interpretation of EU law, referred to in the Windsor Framework, including all the equality directives. It also informs the interpretation of domestic law. provided this Article 2 test is met. Um, and that interpretive obligation is supercharged. When it comes to the application of EU law, arguably the interpretive duty is a very, very extensive one. You must take into account the entire body of domestic law in order to give an EU law compatible interpretation. And we've seen this in particular in cases concerning the application of the Charter of Fundamental Rights, including in cases where the underpinning legislation lacked direct effect, such as the framework decision at stake in Poplawski. Another reason, of course, and this was mentioned earlier, is that the Charter does offer greater remedial protection than the Human Rights Act because it gives rise to this application. But it is also important to remember that in some cases, that will mean that it has the possibility of giving rise to this application, even where the underpinning EU law that brings it into play does not, in fact, have direct effect. So if we do have, say, a measure that lacks direct effect in its own right, say within the sphere of justice and home affairs, the fact that that measure brings the Charter into play is important because the Charter can then lend direct effect to the case. So, for instance, we can have reliance on Article 47 of the Charter directly, even if the main provision that is being relied upon to bring the Charter within the scope of the case is not directly effective. A good recent example is the KL judgment. Where we had a non-directly effective provision, and Article 47 was actually used to provide direct effect as an alternative. So, it's important to note that the Charter can be an alternative avenue for this application. Now, the other thing to note is that unlike the Human Rights Act and unlike underpinning measures such as directives, we have not seen this so far because all the cases that we have had concerned state action. But nevertheless, directives don't apply to private individuals, to cases that concern matters, private litigation, so private disputes. We could, however, have an application of the Charter in those cases. And so that could potentially widen the scope of issues that are brought within Article 2. It may not just be the actions of government, it may also be the actions of private entities such as private employers. This is the traditional position on the Charter in European Union law. So there is, I think, that possibility as well that is important to note. And now, why does this matter substantively? So it matters procedurally, obviously, because the remedies are greater. It also matters because there is broader scope for EU protection for certain rights compared to the ECHR. So this is especially true, of course, of equality, and as is highlighted by all of the Annex 1 directives. Dignity. We see this being fleshed out in Article 1 of the Charter in quite a lot of recent case law in CG and also recognized domestically in AT. On private data, on employment rights, on the entire title of the Charter, and the right to an effective remedy, which arguably goes well beyond Article 6 ECHR. So not only is there a remedial diminution that the Charter can protect against, but there's also scope for the Charter to go beyond the ECHR, particularly in these areas. So there's material aspects as well. So does the Charter apply? I mean, the answer to this is yes. We have had several judgments that have touched upon Charter applicability, SPAC, of course, Angisum, and most recently, and most importantly, perhaps, IMA and Dillon. The Charter applies provided its scope is engaged, as it always did. It only ever applied when the scope of application of the Charter under Article 51, paragraph 1 thereof was engaged, and that continues to remain the case. But the question of whether it has direct effects and whether it gives to its ordinary full set of remedies, gives rise to its ordinary and full set of remedies, such as this application, is much more complicated than that. And in the IMA case, we saw a very clear endorsement of the possibility of the Charter, and particularly of Article 47, to give rise to all of the attendant remedies of EU law, such as this application. But in Dillon, the Court of Appeal states that we adopt the position that the CFR acts as an aid to interpretation of relevant EU law provisions only and makes reference to the removal of the Charter in the Withdrawal Act 2018 to support that statement. So we clearly have an incompatibility between those, or difference of opinion between the courts. This is a Court of Appeal judgment, of course, that is being now tested at the Supreme Court. So it remains to be seen what will happen next. I'll leave it there. Thank you very much.
Thank you very much, Eleni. That was fantastic. Next up is our own Professor Chris McCrudden. If you want to come, are you presenting? And you also have 15 minutes as well. Okay.
Okay. Well, thank you. Apologies for not being here for the first session. I was in court. So what we're going to talk about in this is particularly the test, the so-called SPUC test. But in order to do that, I want to set that test in context. So there are certain things that the test does, and there are certain things that the test does not do. And it's worth knowing. I switched that off. There we go. So maybe the place to start is with what I call the building blocks of the new human rights architecture. And we've talked about these a bit in the past couple of sessions, but let me just concretize it. So we've got Article 2, which I suspect by the end of the day you will be sick of hearing. But then we also have Article 4 of the EU-UK withdrawal agreement, which essentially, in terms of the withdrawal agreement, gives Article 2 its bite. Were it not for Article 4, there would be a problem with Article 2. Thirdly, then we have the Belfast Good Friday Agreement. And then fourthly, we have Article 7A of the European Union Withdrawal Agreement Act, which effectively gives domestic force to Article 2. So the second Article 4 of the EU Withdrawal Agreement gives it effect internationally. Article 7A gives it effect domestically. And in that context, obviously, there is the emerging case law, and a lot of mention has been made of the Dillon case in the Court of Appeal, and I'll say a little bit about that as well. So today, in terms of my presentation, we're effectively focusing on the first of those, Article 2. Yep. Others have been focusing on other parts of Article 4, Good Friday Agreement, and Article 7A. I won't be focusing on that. So I'm also not covering the other provisions of the withdrawal agreement in terms of, for example, UK EU citizens' rights, covering the whole of the UK. Though some of what we're talking about affects how those are also going to be interpreted and applied, because Article 7A applies to those provisions as well. I'm also not going to talk about the Trade and Cooperation Agreement. I'm happy to do that in discussion if you want, but obviously there are extensive provisions there, and as was pointed out, they are somewhat problematic in terms of their enforcement. Okay, so in terms of the Dillon judgment, Dillon is what, 120 pages, something like that. So you'll not be surprised, I'm not going to go through that in detail in 15 minutes. But some takeaway points, I think, are relatively clear. That is that Article 2, according to the Court of Appeal, come back to that, now provides for the wholesale incorporation of EU human rights protections, including the Charter, into Northern Ireland law, obviously with caveats, but that's the basic take-home point. Northern Ireland, therefore, has a human rights framework derived from an international law instrument, that is the withdrawal agreement, which is additional to the ECHR. And so, practitioners are now cottoning on to this in a big way and are drawing issues out of Article 2 of the Windsor Framework much more extensively than previously. The incorporation is not just in terms of the substance, but also in terms of EU law and remedies, and we've talked about that. And therefore, it gives rise to potentially significant read-across effects in the rest of the UK, hence the high degree of nervousness about the Dillon judgment. Okay. Let's then focus on Article 2, and that is, again, the provisions in Article 2. And the case law to date is now becoming really very extensive. So it's now quite impossible to think about Article 2 purely as a textual provision. It's now interpreted broadly in all of these judgments. And sometimes they are not necessarily that consistent with each other. And we'll come to some of those points in a minute. The focus that I'll bring to this discussion is the Dillon case in the Court of Appeal, which has obviously a strong Court of Appeal bench consisting of the Chief Justice, Lord Justice Horner, and Ms. Justice Schofield. So we'll come back to that in a minute. So in terms of Dillon being a key judgment, I think that's now absolutely clear. And it will be, as long as it remains before the Supreme Court gets its hands on it, it is the critically important judgment. So there are certain, obviously, things that are coming about in the near future. One is the Northern Ireland Human Rights Commission application case in the IMA. That's now, as I understand it, stalled pending Dillon, effectively. There is also the accompanying case, as it were, the unaccompanied minor application case, which is an individual application. That's also stalled. In terms of the decision by the UK government, I think there is some confusion as to what exactly is going on with regard to that appeal. That appeal has not been accepted for judgment by the Supreme Court. We're still in a procedural stage where you have to, if you're appealing the judgment, appeal to the Court of Appeal itself, asking for permission to appeal to the Supreme Court. If that is turned down, you can then make a separate application to the Supreme Court directly for leave to appeal. And this is now public knowledge, the Court of Appeal has requested further information as to what exactly the grounds of appeal would be. And therefore, for the moment, we do not know what the grounds of appeal are beyond the general statement that it would consist of issues under Article 2. But which issues under Article 2, we do not know. That will become clearer within the next couple of weeks. And therefore, that will be a very important issue to have regard to when we're considering what the Supreme Court is likely to deal with in the Supreme Court, if it gets there. It is not clear yet that either the Court of Appeal or the Supreme Court will automatically give permission. That is yet to be decided. The news in London, if you like, if I can put it that way, is that they would be likely to grant leave in the Supreme Court, but that's not guaranteed, and we shouldn't assume. And more particularly, we do not know what the issues are going to be. Clearly, in the High Court and in the Court of Appeal, somewhat different positions were taken by the UK government. The Court of Appeal, it was a very widespread challenge to the application of Article 2. And it remains to be seen whether, that being under the old government, that position will be maintained by the new government before the Supreme Court. If they change their mind again, that would be 3 different positions in 3 different courts, as my daughter would say. I'm just saying. So obviously the Supreme Court will have to decide that judgment, that case, if it gets to it. So I have to declare an interest. My instructing organization is in front of me. So I have been representing the ECNI as intervener in both this Buck litigation and the Dillon litigation. So a declaration of interest there. Okay, so this is the basic test. And that's what I've been asked to deal with. So what this test does, we'll go through in a minute, but there are important things that it doesn't do. So it doesn't, for example, address the question of remedies. That's a separate issue, as it were, at the end. Nor does it decide the question or address the question as to whether Article 2 is generally enforceable in domestic law. And that was the challenge that the UK government brought forward in the Court of Appeal, which was to say, effectively, Article 2 is not enforceable in domestic law because it's not, technical term, directly effective. So this test does not deal with that issue. And that's why there had to be a separate part of the Dillon judgment effectively dealing with the justiciability issue. And the court has now decided that it is directly effective. And therefore, it gives rise to an individual remedy potential. Okay. So as it were, at the beginning of the stage, is it enforceable at all? And at the end of the stage, what are the remedies? This test does not deal with. This deals with the question, essentially, as to what this provision means broken down into its component parts. Now, there were various different approaches to what the component parts might be thought to be. So the government, in its explainer document, which was published very shortly after the Act was passed, the 2020 Act was passed, set out a three-part test. The Human Rights Commission and the Equality Commission, in its extremely helpful document in terms of the meaning of Article 2, adopted a somewhat different test from the government. But the test that ultimately has found favor in the Court of Appeal is this test. And so, you know, we can get into wonderful technical discussions and textual discussions about what the differences are between the three tests. Kind of doesn't amount to a hill of beans, to be honest. This is the test that the Court of Appeal has now adopted. This will be the test that, so far, the government has not contested. It has complained about the application of it in Dillon, but it has not complained about the test itself. And so, unless the government again changes its mind, this will be the test that will go to the Supreme Court. Okay, so what are the different bits of it? Let me just say one thing about Eleni's presentation, which is that I think I heard her saying that the jurisprudence of the Court of Justice that's relevant stops at the point of implementation. That is not my understanding. My understanding is that the test for the Court of Justice's jurisprudence is affected by Article 13. And Article 13 of the protocol provides that it is a continuing obligation to apply all Court of Justice jurisprudence that's relevant pre or post implementation period. That's important because obviously, I see nodding in the audience, because obviously, in particular with regard to the Charter, this is not a standstill provision. This is a provision that is a dynamic interpretation. Okay, so with that, I've got 5 minutes to go through some of these. I'll just draw some highlights out of this list. So first of all, does the claimed right engage a right included in the relevant part of the Belfast Good Friday Agreement? That provision, obviously, by the way, all of these have to be met. These are not alternative obligations. Each of these provisions has to be met in the test. So if you fail on any of them, you fail. So does the claimed right engage a right or equality of opportunity provision included in the relevant part of the Belfast Good Friday Agreement? That is so far extremely under-interpreted by the court. And so we saw earlier in terms of the environmental issue, for example, the meaning of civil rights. And that is has been sort of maybe a little interpreted, but not very much. And so a lot hangs on whether you can satisfy that first bit, which is, does it engage a right that's in the relevant part of the Belfast Good Friday Agreement? That is there's a lot to be fought for there. Second, was the Belfast Good Friday right given effect in whole or in part in Northern Ireland on or before the implementation period? That again gives rise to a complexity here, which is not just that you could get a right out of the Belfast Agreement, but has it actually been implemented and given effect in Northern Ireland law? Of course, one of the ways in which it could be given effect is not just by ordinary legislation, as it were, but through European Union law having effect prior to the implementation period. So there is therefore some complexity there as to how you satisfy number two, but you should not limit it to specific national legislation. It could also include implementation through European Union law. Thirdly, was that Northern Ireland law underpinned by EU law? To the extent that you satisfy number two by claiming that EU law is the way in which the Belfast Agreement provisions were implemented, then the third element is satisfied automatically. If it's, however, under two, that the Belfast Agreement right was given effect by domestic legislation, then you have another challenge under three to establish that that domestic legislation was separately underpinned by EU law. Fourthly, was the EU law underpinning removed in whole or in part following withdrawal? We've seen in the context, for example, of the Charter of Fundamental Rights that certain provisions in EU law were clearly repealed, but obviously there will be a significant question as to whether EU law has been, that's constituting the underpinning, has been removed. Not least because, of course, we're into the complexity of other provisions in UK law that continue the effect of some EU law. Yeah, so in other words, there has to be a significant check as to whether the EU law that you're relying on has actually been repealed. Yeah, in many cases that will be repealed, but it's still an important hoop to be gone through. Right, because you do not want to be confronted in court with the government standing up and saying, rather embarrassingly, actually the EU law that you're relying on as having been repealed is still on the statute book. I say that because it is by no means clear or obvious or simple which EU law has actually been repealed or what the status is. And David and his team have done tremendous work on exactly those kinds of questions. Then fifthly, does it result in a diminution in enjoyment of the right? And we've talked about that. Would that diminution not have occurred had the EU remained in the EU, the UK remained in the EU? That is a potentially, and I'm conscious I've got 1 minute, that is potentially quite an important provision. As time goes on, because although the EU law that is generally applicable, with the exception of the Court of Justice jurisprudence, is at the point of implementation period, if EU law changes and reduces its protection, yeah, after the implementation period, then there will be an argument that the diminution would have occurred anyway, because the UK, as a member, would have been forced to implement the diminished EU law protection. And I point this out because in the context of migration policy, that may well be a significant issue. And therefore, from the point of view of the migration cases and the asylum cases, that is something to watch. May I stop at that point, and happy to take any questions later on. Want to kill that?
Thank you so much, Chris. And now we are going to welcome Professor Ruth McAreavey and Dr. Catherine Wright, both from Newcastle. So welcome to Belfast and work away. I will give you timings and everything as you need them.
Perfect, thank you. So a qualifier before we get started. We are not lawyers. I come from politics and IR background, and Ruth is a sociologist. So the research that we're presenting here stems from a report that we were commissioned to write for the Equality Commission Northern Ireland, which was published in March this year. We've also subsequently published some of the findings in the Journal of Common Market Studies a few months ago. So the research looks at the impact of Brexit on women in Northern Ireland. And we very much kind of start and build on this idea that Brexit has been a very gendered project, and there's extensive literature which demonstrates the impact of the gendered impact of Brexit, for example, on the EU. So I've written about that with Tony Hastrop and Roberta Garina on the UK. On Wales, Rachel Minto's done some really important work there. On Scotland, and Ruth and I really add the Northern Ireland dimension there. And this very much builds on the seminal work of Roberta Garina and Anique Maslow, and this idea that Brexit is very much now a realised threat to eroding the legal frameworks and protections for women's rights. In Northern Ireland, we found it was very difficult for women to speak about Brexit, both because of the threat of violence if they were to speak about Brexit, so on social media, but also in familial settings. And also because women's knowledge and perspectives on Brexit were dismissed. So this is what I should have said. We did focus groups with women across Northern Ireland. We interviewed key stakeholders and held an expert seminar. So we spoke to a lot of people about this. And we also commissioned a piece of artwork by Kerry Hanna. This is visual minutes of some of those focus groups. And she's an artist based in Northern Ireland, which is brilliant. So yeah, so this threat of violence for women speaking about Brexit, but also women told that they don't understand Brexit and that men should be speaking about it. That's a bit of background. So we very much conceive and conceptualize Brexit and its impact on Northern Ireland as being a women, peace and security issue. So for those of you not familiar, the Women, Peace and Security agenda stems from UN Security Council Resolution 1325, which when it was adopted in 2000 was groundbreaking. It's subsequently been followed up with 9 further resolutions, and I should probably add that I don't think this resolution would pass the Security Council now, given the current politics there. And indeed, a resolution was on women, peace and security was vetoed a couple of years ago by Russia. So the agenda calls for both the protection of women in conflict and post-conflict societies, acknowledging that women are more likely to be targeted in particular ways, but also calls for their participation. So the importance of hearing women's voices and perspectives to achieve sustainable peace and security. And Catherine Turner and Aisling Swain's research, which takes Northern Ireland as a case study, is really important here. And they argue, and our research supports this, that you actually can't separate the protection of women from their participation in peace and security. So if we find, and we can all agree that Brexit has had an impact on the Belfast Good Friday Agreement, we would expect women, peace and security to be part of the consideration there of how Brexit was being approached, both by the UK, by Ireland, and also the EU. So the UK is quite interesting here. The UK's National Action Plan on Women, Peace and Security was completely silent on Northern Ireland, which it doesn't recognise as post-conflict, until the latest revision published in early 2023. And there, again, it doesn't talk about Northern Ireland in terms of a post-conflict society. It talks about Northern Ireland in terms of domesticating the National Action Plan. Okay, so it's not viewing Northern Ireland as post-conflict, and it's very much also extending this idea of the UK's approach to women, peace and security being a public diplomacy tool for the UK. So, oh great, the UK has this story to tell about women's role in the Belfast Good Friday Agreement. Let's go off and tell it. The other thing from a UK perspective, which has happened in the last couple of weeks, is there's been this push to legislate women, peace and security. So this has come from a private member's bill from Baroness Hodgson. And interestingly, the government is opposing this. So they're opposing it on a number of reasons. They say that it waters down the participation element in the current UK National Action Plan, and that it actually runs against the UK's current foreign policy approach. And on another interesting element, Baroness Foster is supportive of this Women, Peace and Security bill. So this is going through the Lords at the moment. So we'll see what happens there. So there's this blind spot from the UK perspective on WPS and Brexit. Ireland. So Ireland's National Action Plan on Women, Peace and Security covers the whole island of Ireland. We find no evidence from our research and from speaking to kind of Irish officials that there was any kind of consideration that Brexit was a women, peace and security issue. Again, there's kind of dominant narrative that this is about trade. And we know that Ireland very much kind of set the tone of how the EU approached Brexit. Again, the EU has a policy and approach to women, peace and security. The EU completely silent on the women, peace and security here. So we very much see this as a problematic gendered silence. So to drill down a little bit more on this, and Ruth will pick up a bit more on some of this. So one of our findings was this lack of trust amongst women in Northern Ireland, in politicians really, and in kind of Brexit politics. So there's this sense that the kind of Article 2, everything to do with Brexit, was seen as kind of incomprehensible to them. And this made them kind of particularly vulnerable, okay, to kind of gatekeepers in their lives. So we found with migrant women, often they are reliant on men in their lives who might speak English in a way that they don't. And with no actual reliable information from the government on what Brexit means for them, they are very reliant on those particular power structures. So this is obviously problematic. There was also some the other issue that contributed to this kind of lack of trust, as well as this lack of information and information vacuum, was very much this idea that Westminster, the UK government, was not really listening to women in Northern Ireland. So this was something that was picked up in our interviews, and they weren't really that bothered about women in Northern Ireland. And again, kind of the lack of transparency on who the UK government, but also the EU were consulting with in terms of Brexit, bears this out. And what we could find was the UK government very much kind of prioritised meeting with corporate lobbyists over the third sector, and also specifically the women's sector. The other impact here from a women, peace and security perspective to be concerned about is actually the removal of the ability to benchmark the UK in terms of, and the Northern Ireland specifically, in terms of women's rights and how those are being eroded or maybe improved. So the UK and Northern Ireland no longer report to the European Institute for Gender Equality, which has this great kind of monitor gender equality index. So there's no way to benchmark the UK. And this also removes an important advocacy tool for the women's sector. So we very much found, and the women we spoke to very much bore this out, this idea that there were some, if we're going to say this charitably, unthought through consequences and in inverted commas, kind of unintended consequences of Brexit, and that women in Northern Ireland are very much bearing the cost of that.
Great, thanks, Catherine. So, as Catherine said, there's a real sort of perception amongst many of the women that we spoke to, we interviewed, we had focus groups with, about this idea of the unthought consequences, and that politicians, you know, they could not sort of say this was unintended. They really hadn't thought through the implications of what was happening. And we've heard this morning about the complexity and legality around Brexit. It is a really technical thing. And you know, when we were reading into it, Colin very helpfully guided us through some of the process. But he was saying, you know, if anyone claims to be a complete expert in Brexit, then they're not really telling the truth, because it's impossible to get a handle and retain that handle right across Brexit. Okay, so I'm going to speak very quickly. I've got 5 minutes. So one of the things that was really clear is that I would say it's not an exaggeration to say that women felt that they'd been thrown under the bus. And when we started to try and recruit people for our focus groups and people to interview, a lot of women said, but I don't know anything about Brexit. Why would you want to talk to me? And so we were trying to get to the everyday impact and the sort of the sense of where women were at in their everyday lives. And it's really clear that the sort of intersection of austerity, Brexit, the Ukraine war, inflation, the cost of living crisis, it was really hard to disentangle one thing from another. But one thing that was very evident amongst people that we spoke to was this sense of fear. And many women, particularly in the border areas who'd lived through the troubles during the 70s and 80s, were so fearful about, you know, what was coming next, and the fact that the border with Ireland had become quite porous and nearly invisible, and that suddenly it felt really firm and it felt very visible. And people talked about going across the border, frontier workers who maybe had children in the north, but they lived in the south, and the sort of implications of that, particularly for people with different status, migrant status, and yeah, there are very real implications there. So we've heard a lot about our Article 2, and as Catherine said, we're not lawyers, so I'm not really going to say too much on that. We did find women being denied access to services, particularly around reproductive rights, maternity care. And one of the fallouts from Brexit and from the complexity of it is that advocacy organisations were diverting resources into fighting cases and trying to gather the evidence that we were hearing about this morning. And, you know, spending a lot of time doing things like trying to get health trusts to repay money that they'd charged wrongfully. So the other point around the health sort of issue is that healthcare in Northern Ireland is really problematic, right? So there are big, long waiting lists, and Brexit has been a distraction, and in terms of trying to advance some of the everyday lives that impact families, impact women in particular. So there was a feeling that because of the resources that are being spent on Brexit and, you know, picking things up post-Brexit, those resources could have been better spent on education, on health. So, and again, that has massive implications for people. And this idea of uncertainty about what was going to happen in the future. As we've heard today, the legal framework around Brexit is so open to interpretation. But women felt that during Brexit, both during the negotiations and post-Brexit, that things were being done to them rather than with them. And this is the question that Catherine and I have come back to time and again in our research, this removal of individual agency. And we would also argue that Northern Ireland, in a sense, has lost its agency. And it was interesting to see that picture of Northern Ireland being tethered to the UK. And, you know, I think we can think about wider framings of that and tethering to the EU and sort of all sorts of different power relations there. The sort of ongoing monitoring process is really challenging. It is in itself a huge task, and I know that many people in this room are working on that. And, you know, again, that's a massive sort of resource drain. We looked at some of the implications around the resources and the economy and the replacement funds for EU structural funds, EU regional development funds, the shared prosperity funds has been highly problematic. And I know Rachel Reeves in her recent budget has announced plans to evolve those funds. So it'll be interesting to see how that is spent. But one thing that had massive implications for Northern Ireland was that the funds were spent directly from Westminster, and that sort of bypassed the need for equality screening because Westminster is not subject to the same areas of upholding Section 75 duties. And also the EU had supported a lot of third sector organisations, women's groups, organisations supporting migrants, helping people to get ready for the labour market. And many of those organisations had to let staff go. So there's a real loss of capacity there, a loss of expertise, and also a loss of direct services for what we could categorise very roughly as vulnerable populations. So the women's sector has been severely affected by this. And I think the other thing that was interesting to discuss with women was the economic development opportunities and the feeling that, you know, if you look at the parallel economies of the north of Ireland and the south, people talked about, well, if I went and worked for the local authority over the border, this was when we were doing a focus group in the border area, people were able to earn much more money. And it was the economy, the parallel sort of economies, the comparison between the two economies just demonstrated the lack of economic opportunities. And people talked about children going to America, going to England, and they felt that this was due to the lack of economic development strategy, which again is part of this bigger picture of resources being diverted to figure out Brexit. So in thinking through this, we would argue that this is a classic case, Brexit is a classic case of what Nancy Fraser frames around as social injustice. And that has happened across the different spheres of society, and we've sort of touched on it a little bit in this short presentation, but around the economy, around people's social relations, cultural dimensions, and of course politics with a big and small p. And we don't have time to go into sort of the ins and outs of that. So I'm just going to wrap up with the final slide. So we, as Catherine said, Brexit is a WPS issue. And I think, you know, what's really clear from today is how technical Brexit is, how uncertain it is for many people, and how it is a massive drain on resources that, you know, in the past could have been used to uphold human rights and uphold other issues within society. And I think it's interesting to think how, if at all, this will change under the Labour government. We also wonder about Northern Ireland's agency, both now and in the future, because there is this very complex relationship, both with the UK, with Ireland, with the EU. And we also wonder going forward, what is Ireland's role in this relationship? So I think I'll leave it there because I think we're well out of time. Thank you.
Thank you so much. Panel members, I guess if you want to come up and sit and we'll take some questions. It's fantastic. A real varied range of topics there. So and Eleni is still online as well. Yeah, brilliant. So I will maybe take a few questions, and if you wouldn't mind turning your mic on, just so everyone can hear. It's brilliant. There we go. From the floor, if anyone has anything you want to say, we have a roving mic here. Glamorous assistant.
I have two. I'll start with one and then time on second. Just Elaine, first of all, if she would say a little bit more about case law and reading after Brexit, and in particular how to understand CJU versus a common law jurisdiction. You're
Oh, I don't know if I'm just gonna start a bit more. My first question is to put this in the pardon. Would you mind elaborating a little bit more on part 6 of this test and the possibility of EU law lowering the standards? How would that square off with the commitment to non-diminution and with the static nature of the non-diminution commitments? And also to move Kathleen, I know you're not lawyers, and I'm sure there are plenty of lawyers here who'd be more than happy to try and translate some of the social injustices in the language of human rights violations. But I was wondering if during your work, any of the people you work with articulated what potential remedies for social injustice or for feeling like they're left behind Brexit is done to them, if they've articulated any of these.
Brilliant. Maybe we'll take those 3 questions first and go for another round if that's okay. So the first question was to Eleni on case law, CJU and common law as well. Eleni, if you want to add.
Yes, great. Thanks very much. I don't know if that was Alicia, if I heard correctly. I'm not sure because I can't see you all. But anyway, that was a great question. Thanks. And also ties back to the point that Chris was making earlier. Actually, I'm sorry if I misspoke. I'm not so categorical, about the application of CJU case law regarding the RSEO section, specifically after Brexit. I actually agree that CJU case law should be considered to apply. So in the report that we did on the charter, we actually covered this in quite a bit of detail. So of course, Chris is right. The temporal limitation that applies under Article 4 on CJU case law doesn't apply to provisions referred to in the protocol. So it's clear that in respect of Annex 1 measures, the case law has to be prospective. It has to be after Brexit as well. We had some reservations on whether that also includes the broader commitment in the RSEO section. However, be that as it may, I think there is a broader argument from the perspective of EU constitutional law, and that's really what the question, I think, draws out and is about, that CJU case law should apply because the nature of CJU case law is such that it is not applicable from the time that it is given. It is an interpretation. It's a civil law jurisdiction. It's or if you like, of a sort. The interpretations given by the European Court of Justice apply from the beginning, if you like. And where the court wants to make a temporal limitation, it does so explicitly. So there are interpretations of what the measure means. So if we're talking about diminution, I think we do have to have concern, we do have to have regard to how the EU law interpreted, the CJU construes, understands a measure, because ultimately from the perspective of the CJU, that is the correct interpretation as it always was. So even if that interpretation has been given after Brexit, I think there is an argument from EU constitutional law for understanding CJU case law as being comprised throughout the non-diminution commitment. I hope that answers. So there's a difference here, in a common law jurisdiction, in a sense, you'd start considering the application of a case, from the time the case is decided, maybe. But in this jurisdiction, it's very clear that the interpretation applies from the moment that the measure was introduced. And if the CJU wishes to limit the temporal application of the measure, it will do so explicitly. It has done so in very, very few cases. So yeah, that's all I'll say for this. Thank you so much.
Thank you, Eleni. That's brilliant. We had the second question then for Chris on part 6 of the SWOT test.
So to remind you, part 6 is the provision basically that says that the diminution has to be such that it would not have been possible had the UK remained a member of the EU. Yeah. So the question then is, what does that say, therefore, about reductions of standards in the EU? And I raised the point in my presentation that that potentially gives rise to a problem, because if the UK had remained a member of the EU, then it would have been subject to the reduced standard. Yeah. So, and then the question rightly asks, well, what does that do to the non-diminution obligation? So, so there's a problem. And the problem is that Article 2 does not simply guarantee non-diminution, right? I mean, the preamble states it as non-diminution, and the political document stated as non-diminution. But the drafting of Article 2 is much more limited than that. It is non-diminution with regard to rights set out in the 1998 agreement. We talked about that, that results from its withdrawal from the Union, including in the area of protection against, and so on. So it is not simply a non-diminution requirement, it's a non-diminution requirement that prevents diminution, which results from its withdrawal from the Union. And the argument that's going to give rise to the issue in part 6 of the test is, well, there hasn't been a diminution that results from withdrawal from the Union because we would have been stuck with this diminution by the EU in any event. Yeah. And as I say, the area where that I suspect is likely to give rise to most concern is in the area of migration, yeah, where we have seen significant moves being made by the EU to both at the political level and at the legal level to reduce protections with regard to asylum seekers and migration more generally. So this is all to be played for, yeah. But I'm raising it as an issue because, those of you who are interested in pursuing these issues need to know that they have to address that problem. Could I make just one further issue that arises from your very interesting presentation? And it's just the point about Section 75. Okay. Of course, this is wonderful because the issue that I was in court in this morning was on Section 75. Okay. And to do particularly with the application of Section 75 to the budget. Okay. And particularly the application of Section 75 to the budget and the Northern Ireland Office. So the Northern Ireland Office is designated under Section 75. The question is how far the Section 75 obligation that clearly applies to the Northern Ireland Office extends into its activities in Whitehall. Okay. Yeah. Yeah. So I would not want the audience to think that there is not a live Section 75 issue here with regard to precisely the issues you're raising. That's still to be played for. Okay. And there will be further developments on that front subsequently. Yeah.
Thanks. Thank you, Chris. And we're on into our final question. I think possibly our final question before
we have an answer for the question.
That's brilliant. Yeah. And that was on remedies for social justice.
Yes. So thank you. And I'll talk about remedies, not in the legal aspect, and I'm sure the lawyers in here would be able to interpret. But I mean, there's lots of things that could be done to remedy some of the injustices that we came across. And I think the biggest thing is around information, misinformation, and the information vacuum. And by sort of addressing that would go a long way to sort of, I guess, helping people to maybe be a bit more trustful, but not least to remedy some of the injustices. And so obviously close monitoring of all of the issues that we've been hearing about today is important, and having a very easy and accessible information source that is kept up to date. That was one of the recommendations we made in the research. Core funding for the women's and the third sector, I think, is super important. And if we go back to the shared prosperity funds, the way the funds have been spent to date have really been around very large scale capital projects, which does not replace what was there before, you know, through the European Social Fund, or even things like in rural areas, the leader funds and the rural development funding. And I think the other issue is transparency, and going back to how they were the shared prosperity funds were allocated in Northern Ireland, there wasn't very much transparency. And I think having more transparency in policy making processes, rather than paying lip service to participative democracy, would be very helpful. I mean, it's basically opening up conversations and being a bit humane about how we do things. And yeah, and you know, I'm just thinking about the other sort of pieces of research that I've done around migration, the hostile environment. I mean, that's a classic case of just being very sort of negative towards people as a human race and completely abusing human rights. So, yeah.
Could I add a footnote on trust? Because I think your discussion on trust is really critical in all this. So the question is, what's the relationship between trust and law? Mm. And I want to suggest that this is sort of wearing an academic hat for a minute, but with fairly practical implications. The way in which a lot of situations in which there is distrust or potential distrust is addressed is by having legal requirements. Yeah. So in other words, clearly we want more in a trust relationship than simply law, but where there is not trust, then we fill the vacuum to some extent with law. Yeah. So, you know, in terms of a simple contract relationship, I don't trust the people in the audience to deliver on my contract. I have a legal remedy if they don't. Hmm. That has really important implications for the general question that's being asked, because it essentially, from my perspective, means that women have to be able to exercise agency in the context of those legal remedies, right? Because that's what's going to fill the trust relationship, right? If we're able then to get those legal remedies there and they're complied with, then you can begin to think about rebuilding a trust relationship. Yeah, but at the moment, I think it would be, I know you're not saying this, but it would be naive to think that a trust relationship is going to arise, given the lack of distrust that there has been over the past 5 years, without a significant change in the political landscape. And I suspect that's not going to happen until it's clear to the government and other actors that they are going to be hauled up in court if they don't.
Can I just?
Yeah.
I mean, I think that's super interesting. And I think the other thing that was really clear was that women were not treated as equal partners in the discussions and in the debate. So they were completely sidelined.
Absolutely.
Yeah.
Can I come in with a question? I know we're late. Also, I know Eleni has maybe to go somewhere. So if you do have to go, don't worry. Yeah, so my question is, this is pure self-interest, and it's to the entire panel and maybe also the audience. I've been trying to write a paper on labor rights, labor standards, and Article 2 of the Windsor Framework, and I see Marisa smiling because I bothered her with this paper. So my understanding is that labor law is a devolved matter, and Northern Ireland is pretty unique in the UK setting. Pre-Brexit, what was happening is that Northern Ireland tended to follow GB, but it also tended to lag behind, and EU membership sort of acted like it dragged it up, provided a safety net in terms of minimum social standards, right? So my question to you is, to what extent can Article 2 of the Windsor Framework provide the same sort of function that EU membership did? Obviously not as far, because Article 2 is more narrow, but so the question really is, to what extent does Article 2 cover labor rights or employment law in general? Yeah, so it's not an easy one, but might as well take the opportunity.
It is an easy one. And insofar as we know what hoops you would have to go through, but of course there's no certainty that those hoops will be resolved in a particular way. So your point about uncertainty comes in here. But in terms of the hoops that have to be gone through, you would effectively have to argue that the labour right that you're particularly concerned with, and you can't just talk about labour rights as a whole. You have to now begin to break it up into component parts. But to the extent that the labour right you're concerned with fits within one of the specified rights in the Good Friday Agreement, or under the category of civil rights, whatever that means, then you begin to get a potential role for Article 2 in the labour rights context. But the uncertainty as to what the Good Friday Agreement is going to be interpreted as covering gives rise to the uncertainty with regard to labour rights generally. There is one further argument, however, which is that given the extensive coverage of labour rights in the Trade and Cooperation Agreement, it's clear that, I suspect it's clear that the government will argue that since it's been so extensively dealt with under the Trade and Cooperation Agreement, in some way it therefore should be read as not being given effect to in the context of Article 2. I think that's a weak argument, but I'm bet my bottom dollar that it's an argument that would be used.
I'm not going to answer your question because it's too hard and I'm not a lawyer. I just have a comment to make. I mean, I did research whilst we were still in the EU with migrant workers in the agri-food sector in Northern Ireland. And with EU protection, many employers were acting with impunity and discriminating. And, you know, so I think even with those checks and balances, so I guess, yeah, there's a question there about the effectiveness of the legal system to protect vulnerable workers. Yeah.
And I was going to just add something quickly, which builds on what you say. I think it's also about it, if it is the case, it's about workers actually knowing
exactly
what their rights are, being able to understand it.
Yeah, so if you get the situation of a worker in tied employment or working in a mushroom farm and they don't really know where they are, because I've come across people who, you know, were either side of the border, they don't know their rights and they don't want to stick their head above the parapet and raise these difficult questions. And I know there's still a lot of exploitation in the agri-food sector. So very interesting paper.
I don't have a lot to add to what's already been said, other than just to echo what Chris was saying earlier. As long as you can prove a diminution insofar as a labour law measure was underpinned by European Union law, then of course you can have an application of Article 2. But I do also want to just highlight, of course, that we already do have an application of labour law or aspects of labour law through Article 2. Many of the Annex 1 directives are about employment and pensions. So, you know, to a certain extent, they are about the sphere of employment, albeit not necessarily all employment rights, and certainly not collective employment rights or all collective employment rights, or minimum working conditions. But we are increasingly seeing case law from the CJEU that ties those other employment protections, especially protections against unfair dismissal and working time, to various other provisions, for example, discrimination and Article 47, effective remedy. So provided you can jump through the hoop of the SPAC test, or you just bring this within the scope of one of the listed measures in Annex 1, I really can see no reason why labour law would not be covered. In fact, it's probably, for me, one of the most exciting areas of application of Article 2, and one which should be of real significance and relevance for employers, whether public or private.
And in that context, I agree with all that. But in that context in particular, it's relevant that the explainer document that was produced by the government that I mentioned earlier on specifically mentions particular labour rights outside the context of the equality rights. And so it's really important that that explainer document be brought into focus and attention, because most of the arguments that are now being made with regard to the limits by the government on Article 2 have been dealt with in the explainer document, and it's an attempt to reverse what had actually been agreed by the government in the explainer document itself, including in the area of labour.
One of the questions you were asked, I'm going to keep on going. From the Senate contingent, I'm going to sit there. And so the federal action has to go as support the comfortable to the right of the fundamental rights and the other judgment of no reason to be the power. So we talk about this for world, we're not thinking down as well. Is the civil rights broadly as, for example, general acceptance of dignity to international human rights laws and that's the case. For example, Article 7D or Article
Yeah.
to definition and clarify terms that were included in the old standards, which we are fine. Without clarification of that.
And in that case, the equal pay area is obviously one of the classic areas in which that issue is going to arise. But same issue. Sorry, Ben. May I ask Eleni a question that's been sort of burning, if I may? So,
Yeah.
so Article 2 of the withdrawal agreement specifies what union law consists of. And that includes international agreements that are entered into by the EU. The withdrawal agreement, including the protocol, is an international agreement entered into by the EU. Why, therefore, does the Charter of Fundamental Rights not apply to the interpretation of any provision of the withdrawal agreement, including Article 2? Because, as you rightly said, the Charter of Fundamental Rights applies where you're implementing, where the member state is implementing EU law. Well, EU law includes these international agreements. And since Article 4 of the withdrawal agreement, sorry to be technical, requires UK courts to interpret the withdrawal agreement in the same way as EU member states would interpret it, why therefore doesn't the Charter of Fundamental Rights apply to any provision in the withdrawal agreement, including Article 2?
I think it does apply to the interpretation of any provision.
That's what I hoped you were going to say.
Yeah, so I think it does apply, and I don't see any way of the Court of Justice ever saying that the Charter would not apply to the interpretation of the withdrawal agreement. In fact, it has previously found that the Charter is relevant to the interpretation of the withdrawal agreement. So yeah, I'm sorry to be so direct. I'm not sure that there must be more nuance to your question, Chris. I am sure, but if I'm sorry if that is a too obvious an answer. But yeah, that's all I've got. Sorry, I do think it does in terms of the interpretation of any provision of the withdrawal agreement, including, of course, the protocol. I think the Charter is relevant interpretatively. Whether and now I think and many of the issues that we're seeing in the context of Article 2 are really about, well, you know, when is this more than interpretation? When is it giving rise to remedies, for example, such as the supplication, and so on? Yeah, I mean, so are you saying that basically the scope aspect shouldn't be relevant at all? That's quite interesting to me. I'm fascinated by that point. Maybe that's a research line to go down, actually.
Maybe it is.
Okay. I think we'll get lunch now. Thank you so much to our speakers. That was fantastic.